I am so excited that my second year is over. I feel very accomplished in just having survived 2L. I can't wait to spend the summer not being in class. But before I got too far removed from finals and studying, I wanted to give you guys a dedicated video on outlining because it's a pretty crucial part of the law school experience and something that's taken me a lot of thought and trial and error to get to the place where I am now. If you currently are a law student or are planning to be in the near future, I really hope that you find this video helpful. Let's get into it. So I'm going to talk about this more next week in the check-in video that I'm doing and actually already filmed today. But the last final that I just took 2 days ago was for conflict of laws, which was a really difficult class. And I knew that I needed to make an outline in order to succeed on the final exam. I personally have a hard time outlining just by myself, so I was able to find a study partner who would do it with me. But before I get into our process and what that actually looked like, let me give you an outline of what an outline is. Basically, you're taking all of the notes that you took for the class throughout the semester and condensing them into a document specifically tailored to the information that you need for the exam. For some of the cases that you read throughout the semester, this might mean including the facts and details so that you can explain how the court exercised certain reasoning to get to its conclusion or ultimate holding. But for others, you just need the takeaway. And there might even be some cases that really don't add anything new and don't need to be in the outline at all. So it's different than just putting all of your notes together in one document, because instead of just writing down everything the professor says, you're taking a second look at it with hopefully the benefit of the understanding of the entire semester and taking out what you don't need, either because you already know it in your head or because it's not going to be tested. Law students have all different ways of outlining. My first semester, I showed you guys how I had used a mind mapping software to do my outlines, which just gave me some more visual cues of how ideas related to each other. In other semesters, I simply just read through my notes and highlighted things that I thought were important. And in some classes, I use another student's outline. Different things are gonna work for different people, but as a general rule, the idea of an outline is not to create a final product that you can rely on for the exam, so much as it is to study for the exam. It's the creation of the outline that's going to be more helpful than anything you actually write in it. However, if you have an open book test or an open note test, as I did this semester with exams being remote, it is really helpful to either have a physical copy of the most important details and rules and reasonings, or in my case, to have a digital copy and then you can do some Control F action. I think all this will make a little bit more sense though if I just show you what I'm talking about. Conflict of laws was by far the most traditional outline I've ever created in law school, and it's probably the most similar to what law students in general do. So I wanted to share it with you now that my exam has finished. Okay, so I think I have my screen recording for you guys. So this right here is the actual outline. This side on the right is Evernote, which is what I use to take my class notes. You can see that I separated them by class. People can do different things. This is what works for me. But let's turn our attention to the outline for a second. So this is the final thing that I used for my exam. You could say it's pretty long, 47 pages, which I'd say is pretty typical. You know, I have all these different cases in here, headings of the different things that we talked about. Modern approaches was definitely the longest section, so we're going to be scrolling for a while here. You can also see that I did some highlighting. What works for me is to highlight basically like the rule or the main holding. So if I do decide to Control F on a certain topic, the highlight kind of tells me what to read first. And if I'm still confused or still need more context, everything else around it is there for me. But the parts that are highlighted are the parts that I need to make sure that I write down in my answer to the exam. You can see here I incorporated a chart that my professor gave me for the class in case that seemed helpful or came up on a question. Now we're into our next section, which was the Constitution. And yeah, I mean, this is all pretty much the same thing. You can tell it's just notes for each of these cases and then highlighting the rules. Sometimes there's really big sections, like here I was talking about the UCC JEA, which is a really important set of laws that states have adopted to govern this kind of case, which is determining child custody. So if there was any part on the exam that asked me to use the UCC JEA, I wanted to make sure that I took all of this into account for my answer. And then down at the bottom, we put some definitions of things that aren't really like common language or doctrine that didn't have a particular case associated with it, but there were just commonly known rules and definitions associated with. So we put all of that down here. And then I also made basically a mini outline, a mini table of contents almost, for just the various approaches to choice of law, because that's really the focus of this class, and I just wanted to have it all in one place. This ended up being a little redundant actually, because what I also did, and I put this in my notes, is created an attack outline. Again, this is something that people can determine for themselves if they want to do. It can be really different from person to person. I find it extraordinarily helpful. In addition to having this 47-page document, I like to have a 1.5 page max document that's just a list of topics. That's it. Like almost no rules. You'll see on here, it's just like, these could be bullet points, you know? But basically having a list of topics like this without any of the notes, without any of the rules, it gives you a chance at the end of your exam to look over the questions that were issue spotters and just check against all of these issues. This is basically a list of all of the possible issues that could be in an issue spotter question. So an attack outline allows me to read the question one more time, go through this list of topics, and see if anything didn't pop out to me, you know, just thinking of it myself, that now seeing it on another piece of paper, I'm like, oh yeah, I do see that in this problem. So for example, if we had like a child custody case and I know, okay, we gotta talk about the UCC JEA, and I'm like, okay, cool, I'm done. But then I'm going through this list and I see public policy exception. And I think in my head, well, is there a public policy exception to the UCC JEA? And maybe there is, maybe there isn't. But this kind of gives me another way to analyze that same problem. Or I might come down to venue or to, where was jurisdiction? I just saw it. And say, okay, I know I talked about, you know, where this child's domicile would be, but does that mean that that state still has jurisdiction over the case? You know, it's just another way to kind of double check that I'm being thorough in my answer, because that is the key to law school exams, is making sure that you see all of the issues and analyze all of them thoroughly. You can't just say the rule and your conclusion. You have to explain why that rule applies, how it applies, why it applies that way, and then what conclusion that leads you to, as well as counter arguments. So it's a whole thing. I did also want to quickly compare, you know, what my class notes look like to what ends up being in the outline, just to really reiterate that idea that it's not just a compilation of all your class notes. You do want to do some condensing because that's what helps you decide what's important and what isn't. And in a class where it's not open note and you can't bring your outline, creating one tells you what you need to memorize, which I think is dumb because no one memorizes anything in law, but whatever. Okay, so you can see on the right here my class 1 notes, January 19th, 2021. I wrote in what our reading was that day, so you could tell it wasn't all that much, especially for this class. And so then I took some reading notes. I said, this is what the case book is talking about. Let me try to make some sense of it. Here's the first case that we read for that day. This was a screenshot of what my professor wrote on the virtual whiteboard about the case. Here are the facts of the case, my general rule of law, some other things that we talked about, and a note that my professor made about how this case might apply in different areas of the law. And then we talked about another case, Milliken v. Pratt, same thing. I got my facts up here, the issue, what we do for contracts versus torts. And then in class, these are also things that my teacher said that didn't necessarily correlate to a particular case that I had read for that day. So that's a lot of notes, but everything that ended up in my outline from this class is right here. For each class, you might have 2 to 3 pages of notes, but you only end up with 1 page and hopefully less in your outline because you're just taking the critical points. So for example, let's look at Alabama Great Southern, which again, here's on the right what my notes were for this class. It doesn't even all fit in the screen. But this is all that I wrote. Just these, actually, only these bullet points. This one kind of applies too. So this would be the general rule that this case exemplifies. This is the rule as stated in the case. And here's the example of how it applied for the facts of this case. That's what you want to do. You want to reduce it down to just the rule and why, as little as you can. And if you think about it, an opinion can be dozens of pages long. Then you reduce it in your notes to 2 to 3 pages, and you reduce it in your outline to even less than that. And in an attack outline, this is maybe 1 bullet point. So you can see how the process of studying is all about reduction, about condensing, trying to associate just certain phrases and certain case names with the rules and the reasonings that they stand for. This is really something that you just learn through practice, through doing. If you can, I would really encourage you to always have a partner or two. I think it's really helpful so that you can kind of compare notes, and if one of you didn't understand the case, maybe the other one did. But if you're a self-studier, that's fine. This is still a good thing for you to do. I just don't really have the self-discipline to do something like this by myself. It's a big project. We spent probably 30 hours making this outline. So I really hope that this video shed some light as to the outlining process. It is kind of difficult and vague and hard to explain without just doing it, but at least this gives you an idea of what the final outcome might be. If you are in law school and have access to Quimby, something I keep talking about, they always have outlines. It's always okay to look at a commercial outline or another student who's already taken the class and their outline. But remember, the process of creating an outline or something that helps condense the information and makes you actually go through each class and each case again, that process is what's going to be helpful in the final exam. The outline is just kind of a nice side benefit if you're able to use it. But the great thing is, nobody needs to do any of this for such a long time. Most people wait until the end of the semester to start making their outlines. Some of them do them throughout the semester. I don't know. I think maybe it saves you time in the end, but maybe not. I find it more helpful to just wait until the class is over or mostly over, and you have that benefit, that perspective of where we're going in the classes to know how those first couple classes kind of fit in. And you don't have that kind of perspective in your first week or two. But to each their own. If that's what works for you, that's great. Just make sure that you're studying and you're keeping in mind that for the most part in law school, your entire grade is determined by that last final exam. Thank you guys so much for watching and subscribing. I will see you guys next Saturday with another video. And until then, God bless.